We've been making this point now for a few weeks, but one of the reasons Donald Trump was president was because of Hillary Clinton's issues, much, much smaller than these ones, having to do with classified documents. As a candidate in 2016, Mr. Trump repeatedly hammered Hillary for her treatment of classified documents with her email server and insisted that he cared deeply about the sanctity of classified documents and information. He reiterated over and over, no one is above the law.
In my administration, I'm going to enforce all laws concerning the protection of classified information. No one will be above the law. One of the first things we must do is to enforce all classification rules and to enforce all laws relating to the handling of classified information. We also need the best protection of classified information.
Perhaps not surprisingly, all three of those statements by Mr. Trump are cited in the criminal indictment against Donald Trump, in which, of course, he faces 37 charges related to the mishandling of the classified documents he swore he would protect. Let's discuss. And Jamie, let me start with you because one of the things I was talking about with Parlatore is there are 31 classified documents out of hundreds or thousands, and Parlatore was making the argument that, you know, those are the only 31 that were that serious. But you say, according to experts, that's not the case.
Right, and Andy can add to this. Before, I spoke to a senior Justice Department official who explained to me that before this indictment comes out, when you are dealing with highly sensitive classified material, DOJ, the special counsel, goes to the CIA, DOD, all of these. What can we have in the court case? What is too sensitive? So it is likely that there are many other documents beyond this 31, but everyone had to come to an agreement that, okay, we can live with these 31.
But Andy McCabe, the 31 documents aren't shown to the grand jury, right? They're not reading the nuclear secrets to see, oh, this is really sensitive.
Some version of that will actually take place for each of the documents that's cited in counts 1 through 31. Or
redacted 32. Or no?
So they'll use the Classified Information Protection Act, or CIPA, to come up with a series of redactions or substitutions that are agreeable to both sides and can then be presented to the jury. Now, it's important to know that a big piece of that process is the one that takes place before the case is charged, and that is getting the intelligence community to agree to the potential exposure of these documents in the course of litigation. Many Espionage Act cases never go to court because you can't get that agreement. People aren't willing to essentially sacrifice the secret or sensitive nature of the documents.
So in other words, the reason that these documents are cited is because it could have been a lot worse. It probably was a lot worse.
There are probably many documents in the 300 or so that they collected from Mar-a-Lago and however many additional that were voluntarily given back to NARA. There are probably many documents in that collection that couldn't be agreed to be exposed in litigation, like things that were so sensitive that nobody wanted to bring them into court and put them through a CIPA process.
And by the way,
like what? I mean, obviously you wouldn't give us a detail, but like obviously what? Just vaguely, like where we think Iran has its nuclear weapons program? Like
a lot of sensitivity comes down to timing. In some of these documents, if they are older now, it may be that the sensitivity of the source or the collection method or the location, or maybe current events around the world have developed in a way that the content of some of these documents has been exposed publicly, so they're no longer as sensitive now as they were when they were originally classified and considered, super sensitive, important stuff. So there are different ways to kind of square that circle. It's not easy. It takes an agreement across the intel community. But these documents, these 31, have already gone through that process.
But these are 31, not necessarily the 31 worst. Just the 31 that they could get the intelligence community to sign off on allowing in court.
Now, on the other hand, the prosecutors want some juicy stuff to use, right? This is it's gonna provoke a protective and emotional reaction from the jury. That's what they're looking for. So I'm confident that each one of these has been evaluated so very closely to to satisfy everyone's concern that they do constitute national defense information. That's what's necessary for the 793 charge, which is the charge in those first 31
So just
counts.
last question on this. Does this not put the grand jury or the jury at risk? Yeah, not a grand jury, a jury. Well, did the grand jury see these documents too, or no?
The grand jury, I would expect, saw some of them. I'm sure they didn't see all three.
Does this not subject the members of the grand jury and the jury, who are just common citizens, right, who couldn't get out of jury duty, does this not put them in a precarious situation where people might want to know, what they learned, even if it's a sanitized version?
The jurors will never have security clearances, right?
Right.
You can't go through that process.
But they're going to
for
read some
trial.
of these documents.
But they will read some version of the documents. Maybe it's a summary, maybe it's a redacted version of the document to try to kind of limit the worst damage that could be, could come from having folks without clearances seeing these things. But yes, to serve on a jury in a national security case, huge responsibility. And it's something that jurors take very seriously, and it does put them in somewhat of an awkward position.
Well, keep in mind two things. Remember, a grand jury is only deciding probable cause. It will be a trial jury that will have the overwhelming burden. The other point is, you don't get to voir dire your jury. You get the luck of the draw, whoever is assigned to the grand jury process. So the idea of suggesting that somehow it was tailor-made to have one particular result can be fatally undermined in an instance like this. But also, I mean, remember, it was Trump himself who elevated, based on all the statements you outlined about Hillary Clinton, who elevated a crime like this from a misdemeanor to a felony based on the specific gravitas assigned to it. And finally, when you think about all of this, focus on the legal claims that the defense attorneys will be making. They have not said, oh, this was an inadvertent and one document got away, or 20 documents got away, or 31 documents got away. They have doubled down to suggest not that he declassified, they've never made that argument really in an open court filing, but instead that he was entitled to retain these documents. We don't know the answer to three major questions. Why did you take these documents? Why did you want to keep these documents? And why have you tried to obstruct the retention and reclamation of these documents? Those are the questions that will linger for any jury pool out there and have yet to be answered.
It does feel to me, though, that we have some clues about part of the why, right? Both the audio tape from Bedminster and the second example of Trump taking out this document for people in a super PAC. It seems, especially in the audio tape instance, he was trying to use it against
Mark Milley in the first example.
I mean, he trying to use classified documents against people, weaponizing it in that way. That's a little bit of a why. That is a little bit of the intent here of why he wanted to hold on to some of this stuff. It's not totally unusual, I think, if you know Trump, for him to want to hold on to things, to be able to whip them out and to say, see, I know that this happened, and I can't really show you, but I know that this happened. But I do think that they are leaving some crumbs here about the why, and that's very important.
The why almost, well, yeah, okay. Thanks to all.